Judiciary Committee. Senate Judiciary Committee is called to order. And we first have a request for bill introductions. Do we have any bill introductions today? Yes, go ahead, come to the podium, please, and introduce yourself and welcome to committee.
Madam Chair and committee members, good morning. My name is Eric Stafford, Vice President of Government Affairs for the Kansas Chamber of Commerce, with 3 bill introduction requests this morning. Start with the first one, RS 0638. It's concerning legal services relating to advertising and defining and prohibiting certain legal advertisement practices. Again, 0638. Second one is 0644. Relating to litigation funding by third parties. And then the third one, 0643, concerning attorneys and limitations on contingency fee arrangements. 0643 would be the 3 bills.
Thank you. Are there any objections to the introduction of the 3 bills? Seeing and hearing none, the bills are so introduced. Thank you. Do we have any other request for bill introductions? Seeing none, I want to remind everyone that the last day for bill introductions is Monday, February 8th. So make sure you bring those to committee and you get those introduced if you have them. With that then, committee, we will open the hearing on Senate Bill 58. If we could have the bill brief from the reviser.
Thank you, Madam Chair, and good morning, committee. This is Jason Thompson with the Reviser of Statutes. Senate Bill 58 prohibits the filing of certain liens or claims against real or personal property and provides for criminal penalties. Section 1 would be a new statute that's part of our criminal code. It would be unlawful for any person to do one of the 5 things listed there. First, to present for filing in any public record any lien or claim against any real or personal property when such person knows or reasonably should know that the lien or claim is false or contains any materially false, fictitious, or fraudulent statement or representation. Second, it would be unlawful to present for filing any document that purports to assert a lien against real or personal property of any person or entity that is not provided for by law. Third, it would be unlawful to present for filing any financing statement under Article 9 of our Uniform Commercial Code when the person knows or should know that the financing statement is not lawful. Fourth, it would be unlawful to present for filing any document filed in an attempt to harass an entity, individual, or public official, or to obstruct a governmental operation or judicial proceeding when the person knows or should know that the document contains false information. And finally, it would be unlawful to violate a court order issued pursuant to KSA 58-4301, which is the statute amended next in the bill. A violation of this new criminal provision would be a severity level 8 non-person felony. Section 2 then amends the statute I just mentioned a moment ago, which currently provides for an expedited process for reviewing and determining the validity of liens and claims against real or personal property. So that current law lets a person file a motion for judicial review of documentation or instruments purporting to create a lien or claim if they believe that the documentation or instrument is fraudulent. The court can then make findings of fact and conclusions of law, and they can also issue an order setting aside the lien and direct the filing officer to nullify the lien instrument. The bill adds a provision requiring that if the court does make one of those orders, that a lien or claim is set aside, the court would have to make findings of fact and conclusions of law and include an order prohibiting the person who filed that lien or claim from filing any future lien or claim with any filing officer without approval of the court that entered the order. Second, they would also have to state that a violation of the order would be subject to civil and criminal penalties, including that criminal penalty we create in Section 1. And finally, Section 3 amends KSA 58-4302. That in current law provides that after a court has made a finding that a lien or claim is fraudulent under the previous section, the aggrieved person can bring a civil action for damages and injunctive relief against the person who filed or recorded the fraudulent documents. Again, current law provides that violation of that order or injunction can be punished with civil and criminal penalties, and the bill preserves the civil action but it clarifies that the punishment for violations of the order or injunction would be under that new criminal provision in Section 1. And I'll stand for questions.
Thank you, Jason. Committee, are there questions for the reviser? I have a question. Do other states have statutes like this?
Madam Chair, I'll see if the conferees might provide an answer for you on that. I know we had this bill a few years ago, and it received some work in this committee, but it's been a few years. And if we don't find that out from the conferees, I'm sure between us and legislative research, we can get that information for you.
Great, thank you. Natalie, do you have that information handy already?
I do not have it handy, but we can look into it.
Okay, great, and we'll see, perhaps the conferees have that information. With that, then, if there are no other questions from the committee for the reviser, we will welcome to committee Chief Judge Jeff Gehring, Kansas District Judges Association. So welcome, Judge, to committee.
Thank you, members. Thank you, members of the committee, and I appreciate the opportunity to appear before you and appear by WebEx. I'm pleased to offer testimony in favor of Senate Bill 58. As indicated in my written testimony, last year, myself, another judge in this district, and 2 other court employees were subject to these fraudulent liens. This rolled out of a criminal case that was in front of Judge Brown. The litigant was not happy with some of the rulings he was getting in that case, and so his mother filed a lien against my home, against Judge Brown's home, against the clerk of the court, Bernie Lambreras' home, and I think one other. Current law allows for a method to terminate these liens, and kudos to the Attorney General's office for doing that, but current law provides almost no consequence for filing these liens. Most of your, in fact, all of your Register of Deeds offices throughout the state, these are just ministerial offices. And by that, I mean the employees will simply accept whatever it is that individuals file in their office. It's not their job to determine whether the document that they receive and file is a legitimate document, a proper document. Their office is simply there to receive and file documents. Our Register of Deeds office was kind enough to let us know that these documents had been filed, to alert us of that, but there is no real requirement of a Register of Deeds to do that. And worst case scenario is that you don't even know a fraudulent lien has been filed against your home or your real estate until you get to the point where you're trying to sell it, and then you realize that there's this lien in the background of your title history that needs to be cleared in order for you to close on your real estate. So it can be a headache and a hassle to get these liens cleared. While current law provides for the recovery of attorney's fees, oftentimes the individual, in fact, most times, the individuals filing these liens have no money. So there really is no risk for these individuals to use this tactic to harass judges and other elected officials. And for those reasons, I think that Senate Bill 58 provides the much needed and long needed consequence to this. And hopefully by creating consequences and making this a more risky endeavor, you'll see less of it. I'm happy to stand for any questions.
Thank you, Judge, and committee will take questions for all the conferees after we've heard from them all. Next, we have Katie Kopel from the Deputy Assistant Secretary of State, or she is a Deputy Assistant Secretary of State. Please introduce yourself and welcome to committee.
Thank you, Madam Chairwoman. Can you hear me?
Yes, thank you.
I am Katie Kopal. I'm Deputy Assistant Secretary of State for Communication and Policy for the Secretary of State's office. I am pleased to be before you today Testifying in support of Senate Bill 58. This is a bill that our office has worked with the Attorney General on for the past few sessions, and we're thrilled to see it getting some traction and appreciate your consideration today. Our office supports this legislation because we believe it will help reduce fraudulent uniform commercial code filings in our office. The bill proposes a criminal penalty to place responsibility on the filer in determining whether or not to file what might be a fraudulent document. As a Secretary of State for the state of Kansas, our office receives millions of filings a year. Currently, we do not have a remedy or recourse to address filings that appear to be fraudulent. Our role is purely ministerial. A core tenet of UCC and state law provides that if minimum requirements are met for a UCC filing, we must accept and file that document. Filings that may be fraudulent or appear to be fraudulent often meet the basic filing requirements, and our office is looking for tools to help deter such filings. To answer your question, Madam Chair, as of 2019, there were approximately a dozen states that had similar laws on their statute books. This has risen to such concern that the National Association of Secretaries of State has made this part of the subject matter that the different secretaries commonly discuss in looking for tools to combat this. Our office, in full disclosure, does estimate a small number of filings are clearly able to be identified as fraudulent. However, we are seeing an increase in fraudulent filings year over year. The judge did a wonderful job of talking about the impact fraudulent filings have on prominent public officials. On that note, we also believe this legislation would be helpful in combating those tools. It is not a substantial problem in the state of Kansas, but as evidenced by what you just heard this morning, it is a problem. And our counterparts in other states are seeing this becoming an increasing problem against legislators, prominent government staff, public officials like judges. So we do believe this would be helpful in further protecting the personal and business assets of public officials. So with that, I will be happy to stand for questions, and I'll do my best at the appropriate time.
Thank you. Next, we have Steve Phillips, Assistant Attorney General. Welcome to committee. Please introduce yourself.
My name is Steve Phillips. I'm an Assistant Attorney General in Kansas Derek Schmidt's office. I'm here to speak on behalf of the office in favor of Senate Bill 58. Senate Bill 58 is intended to strengthen Kansas's statutes concerning bogus or fraudulent liens. Bogus liens are wrongful liens filed against public officials with the intention of harassing them. Very frequently, it's judges, law enforcement officers, county officials who are the targets. The people who file these bogus liens are often those charged with or convicted of crimes, but they also may be people who do not recognize the legitimacy of our current form of government in Kansas, so-called sovereign citizens. Bogus liens have been an ongoing and continuing problem. As Judge Goering mentioned, within the last year, we had to file to lift bogus liens against 2 Sedgwick County judges and the court clerk. Like many states, Kansas has a statutory mechanism for the expedited judicial review of bogus liens. Under this process, the lien is not removed from the file, but the court order, which finds that the lien is bogus, is placed in the filing system. This works well enough for individual liens, cleaning them up, but it does nothing to deter rogue filers, and yes, we have had frequent filers. In order to stop repeat filers, in 2010, the legislature added a provision allowing damages against rogue filers. And while that legislation was well-intentioned, it suffered from the flaw that Judge Goering mentioned, that many, probably most of the people who file these liens are judgment-proof, and the threat of damages is not a deterrent. Senate Bill 58 proposes 2 things to deal with the problem of repeat filers. It makes filing of bogus lien knowingly a crime, and of course that would require a separate criminal charge and trial by a county attorney, district attorney, or the attorney general's office. Secondly, the bill includes a provision that when the court sets aside a fraudulent lien, it must include in the order a provision telling the rogue filer the person may not file future liens without court permission. And the intention there is to provide further notice to the filer that the liens are wrongful. And Chair Warren, you asked about other states that have statutes like this, and the Secretary of State addressed that. I would add the federal government has 2 statutes criminalizing the filing of bogus liens against federal officials. Thank you for your time and consideration of this bill, and I'll stand for questions at the appropriate time.
Thank you. Next, we have Amanda Stanley from the League of Kansas Municipalities. Welcome to committee, and please introduce yourself.
Chairwoman Warren, my name is Amanda Stanley. I'm General Counsel for League of Kansas Municipalities. I think that other proponents have covered this ground adequately and excellently. We stand in support of this because we have heard concerns from city managers and city clerks in parts of our state about threats of fraudulent liens being filed against them by proclaimed sovereign citizens. The hope is that this legislation will decrease the risk of that. Oftentimes you would never know about it until you went to sell your house and somehow realized that there were lots of these liens against your house that you didn't know had been fraudulently filed. So the bill as written includes local city officials and city managers, and we appreciate that and support this legislation. And I'm happy to stand for questions at any time.
Thank you. Do we have any other proponent conferees in the committee meeting room or online?
Chair Warren, I'm Jeff Easter. I'm sorry, Chair Warren, I'm Jeff Easter representing the Kansas Sheriff's Association and Chiefs of Police and KPOA.
Okay, do you have some oral testimony you'd like to offer?
I'm filling in for Ed today, representing all 3 of the associations. I appreciate you taking the time. I'm not going to add anything else at this point. We provided written testimony, and all the other conferees have really covered what exactly we were going to say, but thank you for your time.
Okay, sure. Yes, I was going to note that we do have proponent written testimony from Sheriff Jeff Easter, Kansas Sheriff's Kansas Sheriff's Association. Any other proponent conferees in the committee meeting room or online? Seeing and hearing none, there is no neutral conferee that has signed up to provide testimony, but is there one in the committee meeting room or online? Hearing and seeing none. Likewise, we don't have any opponent conferee signed up to present testimony today, but is there opponent conferee either in the committee meeting room or online? Seeing and hearing none, do we have questions from the committee members for any of our conferees? Yes, Senator Wilborn.
Thank you, Madam Chairman. I really don't have a specific question other than I'm wondering why the land and title people haven't weighed in on this. It's a pretty big play for them. And also there is an insurance product called, I think it's called Title Guard. I don't know if anybody has any experience with that, but it's an attempt to remunerate the aggrieved person with getting the title fixed. Can anybody weigh in on that, or if not, I understand.
Do we have a conferee who can answer the question? No, I'm not seeing or hearing anyone, but questions are duly noted. Any other questions from the committee? Seeing and hearing none, then we will close the hearing on Senate Bill 58. Thank you all for coming today. With that, we will open the hearing on Senate Bill 60. Could we have a bill brief from Jason, the reviser?
Thank you again, Madam Chair. This is Jason Thompson with the reviser's office. Senate Bill 60 is defining proximate result for purposes of determining when a crime is committed partly within the state. The bill amends KSA 21-5106. That's the provision in our criminal code relating to jurisdictional application. Under current law, one of the ways a person is subject to prosecution and punishment under Kansas law is if the person commits a crime wholly or partly within this state. And one of the ways a crime is committed partly within this state is if the proximate result of such act occurs within the state. The bill would define proximate result as any logical effect or consequence of such act, regardless of whether the statute governing the charged offense considers the specific effect or consequence of such act. And my bill brief gives a little bit of the background on this bill. The language would directly overturn a contrary statement by a Kansas Court of Appeals panel in the case of State v. Roselle in 2020. I note that the Deputy Solicitor General is here to testify via WebEx, so he can get into the ins and outs of that case a lot more than I can, but I did take the language from the case and directly write that what they said was not allowed is allowed under Kansas law. And I would note for the committee that the petition for review by the Kansas Supreme Court was granted in November, so it's currently pending on appeal with the Kansas Supreme Court. And I'll answer any questions if we have them.
Thank you, Jason. Do we have any questions for the revisor from the committee? Senator Thompson.
Thank you, Madam Chair. Jason, would this also help apply to cases where internet fraud, identity theft, things of that nature, some hacker from out of states getting your ID, does this help with that sort of situation?
Jason?
Madam Chair, this is Jason with the revisor again. Because this statute is our general criminal code jurisdiction statute, it would allow prosecution of any crime where the proximate result of the action happens here in Kansas. So I think it would have some application in those cases. And I think the Deputy Solicitor General can get into that a little bit more.
Thank you. Thank you, Madam Chair.
Any other questions from the committee for the revisor? Seeing none, then we will hear from our proponent conferee, Christopher Eisliger, Deputy Solicitor General on WebEx. Please introduce yourself and welcome to committee.
Thank you, Madam Chairman. This is Chris Eisliger from the Attorney General's office. As Jason said, I'm the Deputy Solicitor General, so I handle appellate practice in the courts. This bill is intended to essentially close a loophole that was created by the Kansas Court of Appeals in that Roselle decision. Kansas law already provides for the exercise of criminal jurisdiction when out-of-state acts have as a detrimental effect in Kansas as a proximate result of those out-of-state acts. But the Kansas Court of Appeals narrowed that pretty substantially by stating we can only exercise the criminal jurisdiction if the specific effect of that out-of-state criminal activity was considered and written into the statute, the criminal statute at issue. And they got there by a kind of a strained reading of a 1995 Kansas Supreme Court case where that had to do with impairment of security interest. And in that particular case, the negative effect was the statute, it was the law, but not all criminal statutes are written that way. And you know, the Attorney General would submit that it would be impossible to write statutes that would consider every possible negative effect of a particular crime, especially as what occurred in this case was false writing and insurance fraud. What happened, just to put some meat on some details to this, Mr. Roselle was involved in an auto accident on the Missouri side of the border in Kansas City with a Kansas resident. And then he subsequently made a fraudulent insurance claim against the insurance policy of that Kansas resident. The insurance company got suspicious and stopped it. But you know, we subsequently charged him with making a false writing and insurance fraud under Kansas statutes. And the district court and the Court of Appeals both determined that we couldn't exercise jurisdiction over him because the statutes of insurance fraud and making a false writing did not specifically contemplate any specific negative effect that we could point to occurring in Kansas. Now we've argued that it it is still pending in the Supreme Court, but of course it hasn't been scheduled for argument. There's no timeline for when that will be resolved. And of course we have no way of knowing how the court will come down on that. We think that this is, it's a matter of public policy. We shouldn't allow out-of-state actors to be able to commit crimes that affect people in Kansas, such as insurance fraud in this case. It could be, as someone pointed out, identity theft or any kind of a crime where all of the acts take place out of Kansas but affect people in Kansas. We should be able to prosecute them as a matter of public policy. And this isn't, going out on a limb here. As I noted in the written testimony, the United States Supreme Court, as far back as 1911, said that in a case called Strassheim v. Daley, that acts done outside of jurisdiction but intended to produce and producing detrimental effects within it justify a state in punishing the cause of the harm as if the defendant were there when it happened. And so that's completely constitutional. It has been recognized for more than 100 years by the United States Supreme Court. The proximate result jurisdiction has been on our law books for I don't know how long, but obviously for decades. I mean, the only real case dealing with it was the 1995 case up until now. So it's not. This is not a novel idea. What is novel is the rather strange limitation that the Court of Appeals put on it. So we submit that is just not, as a matter of public policy, that's not a good, and it's not a workable limitation. And in this, these kinds of cases are happening more and more often because not only with the insurance fraud type of case that happened here, but with the internet and identity theft and fraud and credit card fraud and so on. We need to have the tools to bring criminals to justice when they act against Kansans from outside the borders. And with that, that will conclude my remarks, and I will stand for questions.
Thank you. Do we have any other proponent conferees in the committee meeting room or online? Hearing and seeing none, we will then have questions from the committee members for the conferee. Do we have any questions from the committee? I have a question, kind of following along the last comments you made in a question from Senator Thompson. Would this bill were to be enacted and become law in Kansas? In Kansas, we've had a lot of recent problems with fraudulently filed unemployment benefit claims here in Kansas. Would this help the state help prosecute some of those bad actors?
I believe it would. As Jason said, this is the general jurisdiction statute, so it's not specific to any one crime. So I think it would, because the Court of Appeals decision, could be construed depending on, I don't know what specific crime would be charged against somebody making a fraudulent unemployment claim or whatever. There's a whole universe of potential crimes out there, and it's unlikely that the statutes, that all the statutes in Kansas, specifically contemplated the negative effects of those crimes in the way that the Court of Appeals would require them to do for us to exercise jurisdiction. So by resorting to basically a logical definition of what proximate result is, which is any logical result, I think that would assist in with the prosecution of any crime with out-of-state actors who committed their crimes out of state.
So we've got an out-of-state internet hacker, not in Kansas, and they're filing in Kansas. They're stealing a Kansan's identity and filing a false unemployment claim, pretending to be that Kansas resident, but the person filing the claim lives in another state. This bill would allow Kansas to prosecute here in Kansas that person who stole the identity and filed the false claim claiming they were a Kansas resident. Is that right?
Yes, it would. It would certainly clarify that Kansas can. I would submit that depending on whatever specific statute is used, we may even be able to prosecute that now, even with the Kansas Court of Appeals decision. But that decision so limits it limits the proximate result jurisdiction that it makes every one of those potential hypotheticals questionable. So this, I mean, all this bill would do would simply clarify that when we say proximate results, we just mean proximate results. So I think it would assist in prosecuting any kind of crime where the actor is out of state.
Thank you. Other questions from the committee members? Seeing none, then we will turn to our, we have a opponent conferee who has provided written testimony that is in your committee documents. That's from Jennifer Roth, the Kansas Association of Criminal Defense Lawyers. We don't have any neutral conferee signed up to provide testimony, but do we have any in the committee meeting room or online? Seeing and hearing none. And likewise, do we have any opponent conferee in the committee room or online who would like to offer oral testimony? Seeing and hearing none. Just a housekeeping matter, committee. The opponent written testimony is not yet in your hard copy of your committee folder, but it should be available online. And remember that if you're looking for the documents online, you can find them if you go to kansaslegislature.org and click on the committee menu bar and go to standing committees, Senate Judiciary. And then if you click under miscellaneous, that's where you'll find the committee PDF, the PDFs of the committee documents. I'm not sure whether this particular document has been uploaded yet. Do we know if we have that? It just now got uploaded, so the beauty of technology, it should be there for everyone. So with that, then, we will close the hearing with one note on Senate Bill 60. It does not have an impact on prison bed space. There is no impact statement in your committee documents. With that, we will close the hearing on Senate Bill 60. And committee, if you'll then pull out, we're going to work a couple of bills that we've previously heard. We will start with Senate Bill 56, and that was a bill we heard just yesterday. So if we could have a brief statement from the reviser of a brief reminder of what that bill is about. Thank you.
Thank you, Madam Chair. This is Jason Thompson with the reviser's office again. As you recall, Senate Bill 56 is the bill requiring the posting of a human trafficking awareness notice approved by the Attorney General in certain businesses and public places. The current law already requires availability of this notice on some state websites and requires some posting by employers where their employees can see the notice. This would expand the notice to places that the public can view, and would also change it from a statutory description of the notice and the content to a notice and content provided by the Attorney General through rules and regulations.
Thank you, Jason. Any questions from the committee for the reviser? Yes, Senator Pyle.
Thank you, Madam Chair. Jason, can you remind me, I'm trying to remember, what was the penalty if this passes and someone's not posting?
Jason, can you answer that? Go ahead, Jason.
Thank you, Madam Chair. Jason Thompson again. I don't believe there is any penalty provided. It would just be up to the Attorney General to enforce that in whatever way they have available to them, but I don't think there's any penalty in the statute itself.
Thank you.
Any other questions for the reviser? I have a question. Just has this been heard in the House yet this session? Do we know? Mr. Reviser.
Thank you again, Madam Chair. This is Jason Thompson. No, this bill was requested in the Senate only. So this is the first time it's been heard, although it was heard last year as Senate Bill 371. And it did pass your committee and the Senate as a whole 39-0. And it was scheduled for a hearing in the House. It may have even received that hearing, but it died in House committee.
Thank you. Does that bring up any further questions from the committee for the revisor? Seeing none, we'll go ahead and open it for debate on Senate Bill 56. All right, Senator Wilborn.
Thank you, Madam Chair. I most respectfully recommend Senate Bill 56 favorable for passage.
We have a second from Senator Baumgardner.
Yes, Madam Chair, we have had this hearing about this very issue in this committee several times before, and it's needed, so I second the motion.
Thank you. Any discussion? Seeing none, then we will vote on the motion. All in favor, say aye, please.
Aye.
Those opposed, say nay. Motion passes. Committee, I would suggest that we put this on the consent calendar since it last passed 39-0 and there was no opponent and no opposition here. So, Mr. Revisor, does that require a motion? Yes, Senator Paul. We have a motion, yes, and Senator Baumgardner a second. So any discussion on the motion? Seeing none, then all those in favor of the motion, aye, please. Those opposed, nay. The motion passes. Thank you, committee. Committee, then, if you'll please look at Senate Bill 59. That was a bill that we heard in committee yesterday as well. And if we could just have a brief description of the bill from the revisor. We will then work Senate Bill 59.
Thank you again, Madam Chair. This is Jason Thompson with the revisor. Senate Bill 59 is the bill that modifies the crimes of selling sexual relations, promoting the sale of sexual relations, and buying sexual relations by changing terminology to buying a sex act, selling a sex act, or promoting the sale of a sex act, and makes various changes to statutes throughout our Kansas statutes that reference those crimes.
Thank you, committee. Any questions for the revisor? Seeing none, then we'll open it up for debate and discussion. Do I have a motion from the committee? Senator Thompson.
I move to move Senate Bill 59, pass it out, report it out favorably for passage. I don't know if I probably screwed up the motion, but it's close.
Second. We have a second from Senator Gossage. Any discussion on the motion? All right, then committee will vote on the motion. All those in favor say aye. All those opposed, nay. The motion passes. Do we have another motion regarding Senate Bill 59 for the consent calendar, considering that I think Mr. Revisor had said that it passed the Senate last session 40-0. Do we have a motion? Senator Gossage?
So moved.
Okay, do we have a second? Senator Baumgardner? So the motion is to move the Senate Bill 59 to the consent calendar. All those in favor, aye. All those opposed, nay. The motion passes. Committee, if I could just pause for a moment. Excuse me. Thank you, committee. Next, we will turn to working Senate Bill 4. That was one we heard a week or two ago, so if we could have Mr. Revisor please give us a brief description of Senate Bill 4.
Thank you again, Madam Chair. Jason Thompson again. Senate Bill 4 is the bill that would change the penalty for unlawfully tampering with electronic monitoring equipment. The current law has that at severity level 6 non-person felony. This would make it either a severity level 8 non-person felony for monitoring equipment related to supervision of a felony offense, or a level, a Class A non-person misdemeanor for monitoring related to a misdemeanor or a civil case.
Thank you, Mr. Revisor. Any questions from the committee for the revisor? Yes, Senator Thompson.
Thank you, Madam Chair. As I recall, this is mostly a move, Mr. Revisor, to reduce the bed count. Just kind of a reminder of the bill. Thank you.
Yes, go ahead, Mr. Revisor.
Thank you, Madam Chair. I'm not sure I have too much to add. If you looked at the prison bed impact, it looks like it would reduce 6 admissions each year during a 10-year forecast period, save 9 beds in fiscal year 22 and 10 beds in fiscal year 2031. So it's maybe a small number, but I believe the testimony had a lot to do with the proportionality of the offense to other crimes in the code, as well as the few bed savings, if I recall.
Thank you. Thank you, Madam Chair.
Jason, could you help out? I'm not recalling whether we had any opponent testimony in committee on this. I don't recall that we did.
Thank you again, Madam Chair. This is Jason Thompson. I have no listed opponents. Mr. Schultz from the Sentencing Commission was in favor, written in favor from Jennifer Roth of the Association of Criminal Defense Lawyers, and then some neutral oral testimony from former Chief Ed Klump on behalf of the law enforcement associations. They were proponents with maybe some suggestions for a potential amendment, but not opponents.
All right, thank you. Committee, any questions for the revisor? Any discussion on the bill? Any motions on the bill? Yes, Senator Thompson.
Yes, Madam Chair, I move that we report Senate Bill 4 out favorably for passage. I'm working on this.
Yes, a second from Senator Bowers. Any discussion on the motion? All right, seeing none, then we will vote on the motion. All those in favor say aye. All those opposed, nay. All right, the motion carries. Committee, do we have a motion on the consent calendar? Is there something we should have full floor debate on? I'm wondering what the will of the committee is. Senator Corson.
Thank you, Madam Chair. I would move that it be placed on the consent calendar.
Senator Gossage, second. Any discussion on the motion? All right, seeing none then, you've heard the motion. All those in favor, aye. All those opposed, nay. The motion carries. Just a moment, committee. It's the one day I forgot my computer, so I'm having to flip through, so excuse me for a moment. Thank you, committee. Ordinarily, we don't work bills the same day that we hear them, but I think we have some time today, and considering that these were pretty uncontroversial, I'd like to work the bills that we heard today. The first would be Senate Bill 58, and just a reminder that that's prohibiting the filing of certain liens or crimes against real or personal property. Do we need a briefing from the reviser, or we're good to discuss? I think we'll move right to discussion on the bill. Is there any discussion? Yes, Senator Gossage.
I move that we pass this bill out of our committee favorably and put it on the consent calendar since we see no real opposition to it.
Mr. Reviser, can we make the two motions as one motion, or do we need to separate them? I like the thought, but do we need to separate them, or can we make them as one? Mr. Reviser?
Thank you, Madam Chair. It's Jason Thompson again. In many committees, they make it as one motion. You can do it either way. It's the chair's preference.
Okay, great then. Thank you. Do we have a second? Senator Thompson. Any discussion on the motion? Yes, Senator Baumgartner.
Thank you, Madam Chair. I just want to remind the committee that items that go on consent calendar, at least the ones at the beginning of our working bills today, were bills that had been debated on the floor before, that had gone through that process of a vote. One of the benefits of having a floor debate, though it may not be lengthy, it may not be a contested debate, but what it does allow is for the public to hear what this bill does. What are the harms that are occurring within our state? And quite frankly, though I have heard in this committee this particular bill 2 other times, I think what it does is by putting it on the consent calendar, as long as it remains on that consent calendar for the 3 days, it then passes out of the body. But when you think of the testimony we received today from our chief judge, from law enforcement, these are individuals that tell stories of harm that is occurring within their state. So when we bypass that floor debate, truly no one else within our body of Senate hears about why we have this bill before us for consideration, what are the harms that are occurring to Kansans, how this will solve those harms. And so while it is transparent, because it does sit there on the consent calendar, that actual public verbalization, so unless someone goes and listens to this specific hearing in this committee, we have a much larger viewership and listenership to what happens on the Senate floor than on individual committees. And I think it is important for people throughout the state to know how individuals have been wronged, for our county commission to be familiar with these are issues that can occur within their county and that they will need to be able to act and react to. It is unfortunate that we did not hear anything from the title companies. It is unfortunate that we didn't hear anything from the lending companies. But we know it to be a true problem in the state. I will absolutely live within the vote of this committee. I will not ask it to be removed from the consent agenda, but I just want to remind the committee, because we do have new members, there is a benefit to a floor debate. Thank you, Madam Chair.
Thank you, Senator. Senator Thompson.
Yeah, I concur with Senator Baumgartner. Very well spoken, and I would withdraw my second and offer a substitute motion of passing this bill out favorably from the committee.
Thank you. Do we have a second on the substitute motion? Senator Corson. All right, then, committee, is there a discussion on the substitute motion? Senator Wilborn.
Thank you, Madam Chair, and I'd like to opine to also tag on to Senator Baumgartner's comments, which are very well taken. This bill is a product of the criminal justice reform, and it's an opportunity for the carrier of the bill to say, we now have a product from the criminal justice reform, kind of sets the body up for more that are going to be coming down the pike. So I concur with this move. Thank you.
Yes, Senator Gossage.
I want to thank you, Madam Chair. I would like to thank both Senators Wilburn and Baumgardner for the clarification of what that means and why some bills are important to move to the floor. Therefore, I would remove my original motion, and I would also state that another bill we heard today might fall into the same category. Thank you.
Thank you, Senator. Any other discussion? I want to reiterate what was well spoken by Senator Baumgardner, that it's important that the body as a whole hear debate on these issues that has not been heard by the whole body prior. The other two bills that we passed on the consent calendar were prior heard and unanimously passed out of the Senate last session. The third bill that we're putting on the consent calendar Senate Bill 4 has not been so duly heard. However, it is from the Joint Committee on Corrections and Juvenile Justice Oversight. So it has been thoroughly studied by the Joint Committee there, and it's their recommendation that it be passed. With that, is there any? Senator Wilburn, excuse me.
Thank you, Madam Chair. If you don't mind if I opine, I think the ones that we did put on the consent calendar heretofore will be okay. But I think going forward, we duly want to consider Senator Baumgardner's remarks as it relates to educating the body of what we're doing. Some are legitimate consent calendar issues, and I'm okay with those. But I think going forward, we'll watch that.
I think that's wise as well, so thank you. With that, then, we're looking at Senate Bill 58, and we have a motion to pass it out favorably. All those in favor, aye. And those opposed, nay. The motion carries.
Madam Chair, this is Jason.
Yes.
Could you clarify who the second was for those of us listening online?
The second on the motion, the substitute motion second, I believe, was Senator Corson.
Thank you.
Yes. And are we then okay procedurally with where we are on the four bills? Thank you, Mr. Revisor. He said he acknowledged yes, so. Thank you, committee. With that, then, we will be looking at tomorrow hearing Senate Bill 57 regarding statutory speedy trial in Kansas. And I believe we've got a number of conferees signed up, both in favor and proponents and opponents, I think about 8 or 7 on each side. So we should hear some robust discussion on that. So be ready to bring your questions. And is there any other committee business before us today? Seeing none, then we are adjourned. Thank you, committee.